We see state laws being passed in multiple states across the nation, from non-covered service laws to laws that prevent the insurance companies from coming between the doctor-patient relationship, to our House Bill 359 that Tracy and I authored years ago, the network leasing, downcoding, and bundling protections law. But we're seeing federal plans trying to make control over state laws. We begin our podcast right there.
Welcome, all of you fantastic dental podcast listeners, to the My Practice, My Business Dental Podcast Show, where we help dentists profit and thrive with excerpts from the clinical business of dentistry training here at My Practice, My Business. We'll be addressing and answering questions with current trends dentists and their teams face each and every day in their pursuit of this wonderful career we call dentistry. And now the host of our show, the clinical director and president at My Practice, My Business, Dr. Rob Thorup.
Well, I've got to give a shout out to the American Dental Association. This is a really cool thing that I saw in the ADA morning huddle. Nobody has a bigger bone to pick with the ADA sometimes than I do, and some of you know exactly why, but I still am an ADA member because maybe I'm just a believer. But when I see stuff like this, this makes me feel good about our association and what they're trying to do. I believe it's the leadership that we currently have in the American Dental Association that is being a lot more aggressive towards PPO plans and starting to protect the dentists that they should be serving. And this should have happened a long time ago, but hey, this makes me really happy. I want to read this article to all of you because you need to be aware of what's going on. And it's titled, "The ADA Pleads with Supreme Court for Insurance Reform. Federal ERISA Law Should Not Supersede States' Authority." That's a powerful lead, and for those of you who know, you've been able to pass laws in your states, but like the non-covered services laws, if something's non-covered, a ERISA plan can shut you down for even trying to charge for that code and that service. And they can tell you it's non-billable to the patient per our contract because we're a federal plan or a self-funded plan or ERISA plan. All three of those are synonymous, and all three of them just make my blood boil. So let me read this article because you need to be informed on this, and I know many of you probably missed it. So I begin the quote. The ADA is asking the U.S. Supreme Court to review a decision from a lower appeals court on the Employee Retirement Income Security Act of 1974 that limits states' traditional authority to regulate healthcare and insurance. Dental plans have often claimed that a federal law called ERISA allows them to avoid complying with state laws impacting dental coverage if the plans are operating as administrators for an employer self-funded plan. In its amicus brief to the Supreme Court, the ADA continues to advocate that most state laws, particularly those that protect patients and dentists from abuse by dental insurers, sorry, let me stop right there. I'm grateful that the ADA points that out, abuse by dental insurers. Okay, I'm continuing. Can be applied to all carriers, including those administering self-funded dental plans for employers. The 10th Circuit Court of Appeals held last year that ERISA preempts provisions of an Oklahoma law regulating pharmacy benefit managers, which manage prescription drug benefits on behalf of health plans by negotiating prices with drug manufacturers and contracting with pharmacies. However, the ADA called this decision a very expansive view of ERISA, citing the Supreme Court's October 2020 decision in the Rutledge versus Pharmaceutical Care Management Association case that makes it clear ERISA preemption is not extensive. In a June 12th ADA news release, the association states that the ADA brief supports Oklahoma's position that state laws, such as the one it passed, should not be preempted by ERISA. This law regulates the administration of employee benefit plans, including dental care. Some insurance carriers administering self-funded plans argue that the federal law supersedes state insurance laws that protect patients and providers. Let me stop right there in this article. That's the problem. Anytime an insurance carrier can force us to write off covered services, do we even want to do the services? Do we even want to provide the best products, materials, technology? No, we don't. We can't afford it. No business in the world would do that, yet many dentists do. You'll still put in the Straumann implants, the Filtech Supreme, using the best bonding agents. When you're being reimbursed for the LEPAT, the least expensive professionally accepted treatment, or you're being forced to write stuff off, I just want you docs to understand no other business in the world would do that except for you and I. And that's just how we're trained, but not here at My Practice, My Business. We teach you to provide the patients exactly what they pay for, okay? I'm not telling you to do inferior work. I'm telling you, stop your business tactics. You're losing money, and the patient needs to understand why. You cannot provide the best products, especially, and what's funny is Oklahoma here is being quoted, and I'm going to tell you right now that Delta Dental of Oklahoma, Washington, and Hawaii, they're the worst offenders. They're the ones that try to control the quality of care by telling you cannot charge for a MEPAT, a more expensive professionally accepted treatment. You can only offer the LEPAT, and if you provide any value-added service, that it goes against their contract, which it doesn't, but they tell you that, okay? So this is the crap that the ADA is starting to go after, and I love this. Continuing the article, here we go. But in the brief, the ADA and several other healthcare provider organizations state that the appeal court's decision takes an overly expansive view of ERISA preemption and conflicts with Rutledge versus Pharmaceutical Care Management Association by reintroducing the very confusion that the Rutledge decision eliminates. The brief was developed with the American Optometric Association, American Association of Orthodontics, American Academy of Pediatric Dentists, the Association of Dental Support Organizations, and American Association of Oral Maxillofacial Surgeons. It was also supported by the American Academy of Oral Maxillofacial Pathology, American Association of Endodontists, Academy of General Dentistry, and American Academy of Periodontology. The regulation of insurance and healthcare quality are parts of the historic powers preserved for the states and not the federal government. If states cannot enforce laws regarding how healthcare is provided and paid for, then no one can, according to the release. I want to end right there for a second. Let me break in. That statement is very true. We have literally seen some states where the state insurance commissioner or the state insurance commission does not even have a department where dentists can file complaints against insurance companies, let alone this crap from the federal plans. There is no reporting agency on federal plans. You cannot call and file a complaint if they break law. So having the states regulate insurance contracts is where it should be. But even in some states, they don't even have a department to make a complaint. Hello, Montana and others. Okay, continuing. The brief goes on to support mitigating confusion in the area of ERISA preemption, as well as advocating for states' traditional authority to regulate healthcare and insurance. We believe that the Supreme Court should consider this case because the appellate court's opinion appears to introduce confusion and inconsistency in an area the Supreme Court recently attempted to clarify and make uniform in a different case. The ADA and numerous healthcare organizations urge the court to take the opportunity to reemphasize its holding in Rutledge before other lower court decisions further muddy the waters. End of quote. That's the news release. I love it. I absolutely love it. Then there's you can visit, this is a website, ada.org/ERISA. And you can actually watch the the forward-thinking ADA executive, Dr. Ray Colmia. I hope I'm not slaughtering that name because English was not my strong point. So anyway, but watch him. The video is fantastic as he explains to you what you should be looking at on these ERISA plans. And what does this mean? What does this actually mean to you and I out there in Dental Land, USA? It means that those of you who are taking PPO plans, if they can get this law to go back to the state's authority and not be regulated on a federal level, which is exactly where it should go, to the states, not the feds, you're going to be able to actually apply your non-covered services laws, which are in like 44 states right now, maybe 46, which is really interesting. Speaking of which, we watched the state of New York really wrestle with it. I don't even know if they got it passed. I got to double check on that. I'm sure Tracy knows. But it's like, hello, New York, every other state's passed this, but surprise, surprise, you got upper state New York wanting the law, and you got lower state New York, kind of like the west side of Washington and Oregon battling the east side of those states. So you got liberals versus conservatives. Go figure. Go figure. What's best for the patient? Choice. What's best for the patient? Not the constraints of trying to pound down socialistic dentistry into our faces all the time. Well, this is a big deal. If the ADA can work with the Supreme Court and get this passed on our behalf, you freeloaders that aren't members of the ADA, you need to knock your crap off, because this is the kind of stuff that the ADA should be doing for us, and this is the kind of stuff that Tracy and I support. We love this. I hope they get this passed. This would be absolutely fantastic, and to prevent the control of the quality of dentistry that you and I know we can deliver. Hope you all have a great day. Stay tuned for more information coming on this. Thanks so much for listening.
Thank you for being with us today. Since 2006, My Practice, My Business has been teaching dentists and their teams business skills, dental insurance contractual protocols, and state laws governing how to profitably bill patients fairly for the need-based services they provide. What's more, we guarantee our training, unlike other dental consulting companies in the industry. Simply stated, if you don't increase your net revenue, we don't get paid. We call it dental consulting the way it should be. We believe there has never been a more important time than now for dentists to experience and implement our key methods, knowledge, and business training within their dental practices. To learn more about our guaranteed, no-risk clinical business of dentistry training that is changing dental practices for the better, just go to our website, mypracticemybusiness.com, and surf our pages for additional information about our company and the services we provide. When you're ready, give us a call and get scheduled for the most profitable dental business training that you will ever experience. If you enjoyed our podcast, please leave us a 5-star review. If you have any questions, please don't hesitate to call us. Thank you again and have a fantastic day.